welcome all the students and our center members and guests to our Transdisciplinary seminar. The talk that he's generously giving today is on Aboriginal title and fracking litigation in Stormy Weather from the West. And let me just say a few words about Wally. He's a partner at Bennett Jones and is co-head of the firm's National Aboriginal Law Practice Group. His regulatory law practice focuses on assisting energy industry clients with environmental and Aboriginal law matters. He frequently advises on energy projects across Canada, including upstream production, pipelines, LNG, oil terminals, and marine shipping. Wally's acted as counsel on leading cases involving hydraulic fracturing or fracking, water, contaminated sites, and Aboriginal issues. He's based in the Calgary office, but you also work in Toronto and the newly opened Vancouver office, right?
Yeah. Mm-hmm.
So from what I can tell, you work all across Canada on a range of issues that are absolutely central to our work. And I think this is a great example. A lot of times students ask, where can I go with some of my undergraduate degrees? So Wally had done a dual degree here at Brock in geography and what then urban studies.
Then I went to, I was a city planner for a few years.
Right.
I did a master's in city planning, which is a natural bridge from urban studies over to city planning. And I was a city planner for a number of years, and then moved over to law, and I figured...
and here you are today.
Yeah.
So with that, welcome, and thanks so much for joining us today.
Thanks, Ryan. I'm really happy to be here. I'm a fan of Brock. I had a great undergrad program here with great professors, so it wasn't... just simply, I was really pleased to see that this program was underway. I thought it really fits in well with the Brock tradition of a very solid liberal arts school. And I had the benefit of going to a couple other schools. I must say, I think the Brock background served me very, very well. It was brilliant. So I'm more than pleased to come back here and chat a bit about the stuff, some of the interesting cases that are coming down. And I think for many of you, these interesting cases will if you're not a lawyer, certainly in any sort of policy resource area, it will affect you. And this is now a different ball game in some ways, and I just wanted to highlight some of those aspects. So my time here goes back to geography, like Ryan said, and some of you might know, although they've moved on. Bob Hoover, sort of an iconic gentleman, a real gentleman. He was my main guy. I really liked working under Bob Hoover, and Bruce Krujelnicki, another one, and Joe Kushner, the economics prof. I had no idea what Joe was talking about because he talked in intersecting lines, and lawyers don't talk that way. But I took his course. I passed Econ 101, and there's lots of happy stories all the way through there. You'll hear me say in today's discussion, really there's two discussions. Well, I'm going to spend about 20 minutes, maybe a bit more on the Aboriginal title case. I call it Silcoteen. Some others people call it Chilcotin. Other people call it the William, singular, William decision. So it's the same thing, but I'm going to try to stick to what's politically correct for that First Nation, Silcoteen. When you hear me say that, it's really the Chilcotin decision. And so I'm going to break it down roughly. I'll try to stay within approximately 20 minutes. I want to really high grade some concepts on Silcoteen and some of the things that are coming out of the newly emerging fracking case law. You've done the heavy sledding. You've read stuff that probably said there were some foreign concepts in the material that you looked at, and it's tough. It's tough to get into another discipline, but I think you get a flavor of some of the language that's out there. We're not going to go into any nuanced legal discussion today. It's going to be very practical, the implications from especially that Aboriginal title decision. But I think it's important to have some context of the Silcoteen decision, first of all. And I'm going to present the context in two ways, just for a couple of minutes each. You have to understand a bit of the legal history here. Again, without boring down into legal jargon, I think you should recognize that this has been a very remarkable journey for Aboriginal groups, and this is like the it's been decade after decade, and I'll point out why this one decision by the Supreme Court of Canada, in my view, is more significant than probably all the others combined. It's that significant. And so I'd like to start off with going back to late 1960s. I could go back a lot earlier, but at least there's a decision called Calder. The Calder decision out of British Columbia, Nisga'a, the Nisga'a First Nation, said what they believed was true a long time ago. They said, we're claiming Aboriginal title to that northwestern part of British Columbia called the Nisga'a area. And what happened there was it was a seven judge court. It split 4-3. 3 said, yes, they're under the existing law, the law going right back to before Canada was born, but the law that was transplanted onto Canada had this idea, this concept of Aboriginal title, right back from English common law. And so you're talking about royal proclamations. The Royal Proclamation of 1763, for example, very critical proclamation in English law, and therefore Canadian law, Canada being a young puppy that was really was formalized in 1867. So that Calder case came about, and the Nisga'a were saying, we own that land, their words, lock, stock, and barrel. It was a 4-3 split, but then the judge that voted, the fourth judge that voted against the Nisga'a did so on a really lame technicality. It was a heart-rending, hollow victory for the First Nation. But Trudeau, bless him, Pierre Elliott Trudeau, he then said, well, I'm doing a 180. He had the policy for most of the 1960s through Mr. Chrétien to say the best policy for Aboriginal issues is to assimilate Aboriginal people, to make them just ordinary folks like us. The reserves aren't working. So basically what happened at that point, Trudeau, to his credit, I think, and I'm not a liberal shill, to his credit said, I'm doing a 180. I understand that there is a thing called, even though the Nisga'a lost on a technicality, I agree that there's a thing called Aboriginal title in our Constitution, in the common law. So he did a 180, and within a year or so after that, he set up a thing called the comprehensive claims process. That process was not used for a few years, but I'll come back to it in a moment. It set up a system whereby Aboriginal groups who assert Aboriginal title and rights, they can then go and prove out title and basically get into what's called a modern-day treaty. So he set that system up. Then Trudeau also, a couple of years after that, he set up the Berger Inquiry. Many of you will know about the Berger Inquiry. That's the inquiry that heard concerns from Aboriginal groups in the Mackenzie Valley, over the Mackenzie Valley gas pipeline project. So that really, I was at Brock then, in 1974, which before many of you were born. I recall, this is the days before internet, I recall we were sitting in, these buildings didn't exist, over in something called Poesis Lounge over there, which is now probably something else, I'm sure it is. And we had the radio going. CBC carried live coverage of the hearing 6 hours a day, every single day. And it was spellbinding for a kid from the suburb, and many of us were kids from the suburbs, did not know what the Denny were, didn't know what they were. We thought there were a bunch of Eskimos up there. We knew nothing about the Mackenzie Valley Pipeline project. We had no idea how all this stuff worked. That was one of the biggest things going on in Canada, but bless them, CBC had this thing going on. It was absolutely fascinating to hear elders speak, often through translators, about what's going on up there. And it was all about Aboriginal title then. And these Aboriginal groups were saying, we cannot go anywhere without Aboriginal title being resolved. I won't go into detail, but then Trudeau, Trudeau, in 82, then led the charge to have a constitutional amendment which introduced a so-called Section 35, which affirmed the Aboriginal rights and title and treaty rights. So basically, what that basically means in one sense is that ordinary legislation cannot trump, breach, or abrogate those hallowed principles under Section 35, including Aboriginal title. In the 1990s, a bunch of treaties rolled out north of 60, especially in the NWT, and more in later terms, Yukon. So a number of treaties rolled out at that point, modern day treaties north of 60. A number of decisions, important decisions came out in the 1990s as well. Sparrow, don't worry about writing them down. Sparrow, Delgamuukw, might refer to them again, but they were very, very important decisions to help establish what I'm going to call an Aboriginal title framework. There's a really, it's not mathematical, but it has a number of components that kind of wire to each other. It's a framework, about 7 or 10 key concepts. I'm not going to drill down into those 7 or 10, but you got to understand that this is not just an ordinary unstructured process of figuring out what title is. It's actually a bit of a formula. And so those decisions like Sparrow, Delgamuukw, and others were the basis for this framework that was ultimately used by Silcotin. I'll mention one more case, and then that's it before I get into Silcotin. 2004, the Haida decision. What that decision was all about, you'll hear me maybe talk about the stream of Haida cases. Haida was all about consultation. It's all about the judges there, and I've got the benefit of working with Justice Jack Major in our firm, who was one of the judges on that case. And I had dinner with him a little while ago, and he said, really, that case was, what it comes right down to it, what we're trying to do there as the Supreme Court of Canada was simply to try to reconcile that the fact that the Crown has certain rights already, but Aboriginal groups have many solid grounds for asserting Aboriginal title and other things. So we have to find some way in that case to have these assertions, which are very legitimate legal interest by the Aboriginal people, to meld together and try to live together in a way, keep the assertions alive without stripping out, letting the Crown rights strip out these asserted rights, having these two sets of rights or interests live together. So that was Haida, and the outcome of Haida was really the need to have all kinds of consultation. Whenever the Crown wants to do something, you got to have consultations with Aboriginal groups. And there's been dozens and dozens. I've lost track. I've been in a number of these cases myself of so-called consultation, Haida consultation cases since 2004. I should also draw another link before I get it. I am now going to get into Silcotin, but before I do that, I got to tell you that there's a strong Niagara Genesis to all these cases I just talked about. 3 lawyers have been spectacular in their work on this. There's 3, if there's 5, they would be in the top 5, these 3 lawyers. Joe Arve, who is the preeminent go-to lawyer, you got to have him in your corner. You have to have him in your corner. He's been to the Supreme Court of Canada on every one of these decisions, and he's from Welland, 10 kilometers south of here. Another leading light, and I really stress leading light, is a guy who is now an MP, poor guy, in the NDP caucus, a guy named Murray Rankin, Lakeport High grad, he's in North St. Catharines. And then the third person is a guy named Jim Aldridge, an econ major here from Brock. He's a St. Catharines boy as well, and he graduated through economics, so he did understand curves. So there's I don't know, what is it, the fine Welland River drinking water? I don't know what it is, but there's somehow it's spawned a lot of good lawyers on the Aboriginal front. So what about this case in particular? Okay, the Silcotin First Nation is a band of 400 people in a very, very remote part of British Columbia. There's very few roads up there. we went, I say we, my daughter's here, so we went to some way off the beaten track once on a purported vacation. It was just very rough, remote roads. That was Silcoteen area. And there are the very traditional still. People, many of the elders do not know English. And so this, what really drove them crazy was that there was a forest company that was allowed to go into their lands on lands that they've valued very much for sacred and other reasons. And that forest company was given the rights, tenure and the cutting rights under that tenure, time and time again, without any consultation from about 1985, or even before then, onward. So there was a roadblock or two along the way in the sort of sordid saga. The Crown didn't know how to spell consultation. They did not talk with the First Nation, and enough was enough after a while. So what happened is a company, a law firm, Woodward Company, started an action. They said, okay, we're going to have two objectives. I'll discuss them in a moment, but this is going to be a very, very large job. We're going to prove out. Now, we're not just going to assert things. We're going to prove out title, and we're going to prove out rights. And so it was a very interesting exercise. Woodward Company rounded up a bunch of 20-year-old lawyers, young lawyers, and they frankly, virtually worked for free. And the litigation took some 25 years. That's how long it took. It was an enormous enterprise to prove out on a hectare by hectare basis what was there, and to meet all the various judicial criteria of the onus. There's a huge onus on the First Nation to prove out that they had the rights, and more importantly for them, they had the title as well. So they had two objectives. The lesser objective really was to prove out that they had, quote unquote, Aboriginal rights to use Crown land, rights to hunt, fish, and trap, and so forth. Because until then, they were just asserted rights, so they want that proof. And so what do you get? A paper on the wall saying you now have confirmed Aboriginal rights? Well, it goes way beyond that. It's about money. And basically, you can then say, if you're breaching my confirmed right, you're causing damage to me. And we can now bring a follow-up action and damages, and that's what's going to happen up there. More importantly, the second part of their litigation strategy is to say, we own this. This is not Crown land, we own it. That's the harder slog, and they met that test spectacularly. They proved out title to some 400,000 hectares. That's title. There's other hundreds of thousands of other hectares just on Aboriginal rights. So it was a spectacular success for the Aboriginal group. And I'll tell you exactly how it's going to roll out practically. Now you might say, well, does it apply only in British Columbia? The short answer is no. It's going to apply certainly that area. I'll tell you how that's going to happen, how it is rolling out there momentarily. But in other parts of non-treaty British Columbia, for example, there's also parts of non-treaty, there's still non-treaty parts of the Yukon, non-treaty parts in the NWT, the Decho. There are many so-called peace treaties in the Maritimes. New Brunswick, Nova Scotia, PEI are all peace treaty areas which do not have so-called surrender clauses, land surrender clauses. And even in the treaties with so-called land surrender clauses, some of you might have bumped into the term numbered treaties. On the prairies, for example, in northeast British Columbia, where all the shale stuff is going on. There's some of the Silcoteen principles can be applied, I'll give you a flavor of that later on, can be applied to those numbered treaties, which purport to extinguish land rights that were held by the Aboriginal groups. So there's a lot of mop-up litigation that's still going to happen after Silcotin. Okay, so I'm going to rattle off through, I'm limited to 12 implications, okay, for arising from Silcotin. Number one, probably the biggest one, is that there is now a huge amount of confidence on the parts of Aboriginal groups. They have suffered through victories, but hollow victories. Delgamuukw was one, and Calder was another one, and I can think of 4 or 5 others. Finally, they can apply a legal framework that's set in law and say, we have applied this framework and we look at the results that we got. Other groups are going to say the same thing and say, aha, it's no longer about going cap in hand in limiting our strategy to consultation only. So we're just going to move right into the business of proving out not just that we have the right to hunt and fish on the Crown land, we're going to the business of ownership. The debate has changed as of June 26. It's now all about who owns the land after June 26. So that's the fundamental. People say this case is a game changer. This case is a game changer. I disagree that it's a game changer in the sense of the law. The law was there. What the case did, and basically it said, we are using the old cases called Sparrow, Delgamuukw, Garin, etc., and we're tying this all together. The principles are there. We're not making up new stuff here, the court said, and we're applying it, and we're reaching a conclusion, and it ultimately is a spectacular result for the Aboriginal group. So it's the wind in the sail. That's the number one implication. That's the game changer, and it's going to reshape strategies, and they already are reshaping strategies in the 7 months since the decision came out. It's gone. Aboriginal groups were very frustrated with by putting their eggs in the consultation basket. That is, by going to say, you didn't consult with us, we're asserting Aboriginal rights to hunt, fish, and trap here, you didn't consult with us, we're taking you to court. So, and then often they won those cases. There's been a whole string of Haida cases that the First Nations have won in recent years. And as one Aboriginal person told me, they said, well, winning in a consultation case is like winning the pie eating contest at the country fair. What's the prize? More pie. So that's the remedy. It's a different remedy if you have proven, like I said earlier, you have proven rights or proven title, you actually own the land. So wind in the sail, number one. Number two, are we going to see more Aboriginal title cases? We won't see more along the scale that we discussed of this one. Silcotin was unique for various legal reasons. They really cherry-picked a very nice spot to go after the title. I think what's going to happen is that Aboriginal groups will cherry-pick and strategically go after 4 hectares, not 400,000 hectares. Cherry pick in a couple of contexts. A, they're going to cherry pick, coincidentally, that 4 hectares is going to lie where a mine site is, lie where Enbridge Gateway right-of-way is, and they're going to just go after those sites and they can prove out that 4 hectares very quickly, as opposed to the 400,000. And go to the cost. The cost incidentally is not small, $5 million a party in the Silcotin case. And that's conservative. I think there's much more. I think it's probably double that. And don't forget, it was basically on the backs of young lawyers for the Aboriginal groups who didn't have high expectations in terms of compensation. The other strategic reason for going after the 4 hectares versus much larger areas is the economic sweet spots. There are some very good sweet spots. The Aboriginal groups might well conclude, we'd rather own that mine than have the mining company on. Maybe we should be the owners of of those minerals, as opposed to the Crown. So they're going to, whether it's forestry, minerals, or some fisheries, something of great value, they will go after those sites. So we're already seeing, some of you will hear that the Seco mine issue in northern BC. They're already seeing that the Silcotin First Nation, which didn't the Aboriginal title lands didn't quite go so far as to capture that Taseko mine site. Now they're talking about, well, we can also prove out that mine site. So that's an additional factor in the resolution of where and how Taseko might go. That's an example. It's already clearly out there as a next step. Implication number 3. One thing the Aboriginal groups have to be aware of is overlap. To prove out your area as Aboriginal title, you have to show that since the day of sovereignty, deemed to be 1846 in British Columbia, 1750 in Maritimes, don't ask me how to explain that. But anyways, what goes on there is that the First Nation, to prove out title, they have to show that they had exclusive possession, quote unquote. What that means is that you had yes, other First Nations might have gone over the territory, but you're the ones, you were the big dogs. You were able to control who comes on your lands and who cannot come on your lands, and under what conditions. Silcotin were able to do that. There was very little overlap, unlike a lot of other parts of British Columbia where there's a lot of overlap and tighter quarters. This is a remote area. So it is, I do think, and I know so, that Aboriginal groups are wrestling with this right now. There are discussions underway and have been since the decision came out. That exclusive criterion will not go away. It's now entrenched in law. No one's going to upset that criterion. So Aboriginal groups know they have to sort of do an arrangement, if you will, with their neighboring, overlapping, competitive Aboriginal groups. So that rationalization is happening, and it will happen. I think Aboriginal groups will know full well that they have to jump over that burden first. So that overlap issue that you often hear about across Canada, including especially in British Columbia, is going to, for the reasons of proving title, is going to start to resolve itself. So the fourth implication is that Aboriginal title lands can be used by the title owner, the Aboriginal group, for a wide array of purposes, from preservation to heavy industry. It's not tied to traditional uses. They are owners. At the same time, these title lands are not Indian reserves. And as some of you might be surprised to know that Indian reserves are not in fact owned by the Aboriginal groups. They're owned by the Minister of Indian Affairs, the federal government. And with that federal ownership, there comes a lot of Indian Act type of hamstringing that goes on a reserve. So what happens here is that there's Aboriginal title, you own it. So basically, you've got, it's not unlike, some of you who own private property, it's not unlike fee simple ownership, the highest and strongest form of real property ownership. There's a lot of similarities to that, but there's a few unique aspects to Aboriginal title you don't find in fee simple. First of all, the Aboriginal group cannot sell those Aboriginal title lands, except to the Crown. You can't just sell it to, you can do a deal with a mining company, for example, and lease it out for a certain time, but you can't give it away. Okay, so it has to go back to the Crown if you want to give it away. Two, the Aboriginal group, and this is a tricky one, it can certainly go down the path of industrial development, but the lands have to be preserved, I forgot the exact words used, have to be preserved for the future generations of the Aboriginal group. If I own a property, I don't have to think at all about preserving it for my daughter at all. Whereas if I'm an Aboriginal group, I have to think about the long-term effects for the future generations and how whether they can benefit even with industrial use and benefit from that site. The third thing is that, and this is on the Aboriginal group side to their advantage, the Aboriginal title lands are not subject to land use zoning, for example, except in the case of infringement. I'll talk about the infringement policies or rules in a moment, but you're not subject to zoning. Like as a fee simple owner, I have to respect the local zoning laws, and that's not so on Aboriginal title lands. Okay, then the next implication is the Aboriginal groups have a very important card to play, the consent card. Okay, so you prove out ownership. You prove out rights to hunt, fish, and trap. But the framework, the legal, the Aboriginal title framework essentially says that the Aboriginal group now is the proud new owner. Well, it's been affirmed to be the proud new owner. You know, it's never, let's be very clear on this. It's not that the court does not grant or convey title to that Aboriginal group. It's simply they declare an affirmation that has been there for a long time. It's a very important distinction. I mean, no one's giving anything away. That's being there, it's been there since day one. So that's what the court's function is. And so but now that there's this proven title, there is a consent. There's a formal consent rule. The Aboriginal group, let me illustrate this, what's going on in Silcotina as we speak. In the weeks and months after the decision came out, the Crown, when I say Crown, it's often federal and provincial, but in this case, especially the province, the provincial government, is negotiating with the Silcotina First Nation as to which statutes, provincial statutes, are going to apply on those Aboriginal title lands. So they're cherry picking. And in fact, they're looking at it through the lens of co-regulation as well. That First Nation, it is very, it's not a militant First Nation in the sense that they don't take a strong anti-industry perspective. What they want industry, they also know that they do not want a stranded asset. They got this big, massive piece of land. They do know they want to use it for economic development one way or another. But so at the same time, they realize that what industry needs is certainty, and certainty, good or bad, it can be found in legislation. You know what's there. Companies need to know what it is that the rules that they're running under. So, there's this very unique new form of negotiation that's going on about importing certain statutes, provincial and I'm going to assume federal as well, onto those on those title lands. So they're making up a new wheel here. They really are, and we'll see. And I think part of that wheel is going to be the co-regulation spokes. You know, basically where decision makers. This is not co-management. This is co-regulation. There will be decision makers, it will go beyond what's found in the treaties north of 60, where the Aboriginal groups sit in the chair of the decision maker, the regulator as well. They're perhaps together with Crown representatives, but they will basically wield the legal clout as to on deciding. And whether that's through environmental assessment, permits for pollution control, it's all up for grabs. The sixth the matter is Aboriginal. Well, you might ask, well, what about comprehensive treaty making? I alluded to this earlier on. You know, I'm not. I have no illusions. I don't think there's going to be a lot of treaties being made, these comprehensive treaties. I mean, there was a big talk about, well, shouldn't there be some, well, let's do a bunch of comprehensive treaties. You know what, we've had a very moribund treaty-making process in British Columbia. And that moribund process has led to some three or four treaties in the last 20 years. And there's no rush on to fix that system. And indeed, there might be a disincentive to fix that system because the expectations are, rightly so I think, much higher on the part of Aboriginal groups. And Aboriginal groups will now say there has to be more land and cash. So the threshold negotiations will have to be between the feds and the province as to who's going to pony up the land and cash before they even start negotiating a comprehensive land claim agreement with the Aboriginal groups. So that's another consent. I'm going to rock it through a few. I know we're a little short on time. Consent. So what's happening in British Columbia especially, and more so in other provinces, is that there's consent granted by the Aboriginal group by what's called sub-treaty deals, more of an ad hoc type of arrangement. an Aboriginal group or groups might want to say, well, we like LNG. Okay, so we're going to enter into a number of LNG specific agreements. And so we're going to consent, even though we haven't proven out title there yet, we're going to consent on a forward-going basis that the LNG can happen here, and you have our consent. So we're not going to jam you with an Aboriginal title civil action. It's not a panacea. There's got to have willing partners. In some cases, there's bun fights between Aboriginal groups and rivalries that take place because some of the deals are being made with groups A, B, and C, but not with D, E, and F, and D, E, and F feel aggrieved that they should be part of the deal. So that's a complicating factor. There's nothing wrong. No one is casting aspersions. It's just a reflection of the overlap and the arrangements made over history amongst the different Aboriginal groups. So it's a hard reality to face up to and deal with when you're doing the sub-treaty deals. Okay, let's now talk about the last couple of minutes on infringement of title. So if the First Nation does not give consent, what happens then? It's not the end of the legal story. There's the infringement that can happen. The Aboriginal group still has to recognize that the Crown has a hammer, and it has the hammer of infringement. But the Crown is reluctant to hammer with infringement because it can be, for two reasons. One, they don't want, BC government especially, at this point, much prefers trying to reach consent arrangements rather than use the adversarial hammer of infringement, which would not go over well these days. It just would not. It's not the right time to be going about infringing title. So there's really two main things that the courts look for to allow, in their words, to justify infringement. That's the coined word. Justifiable infringement is a very key, important point. The first one, there has to be consultation. Consultation in a retroactive sense. This is what the court was very critical of in Silcoteen. They said there was very poor, if any, consultation even before there was a proven title about the forestry. So already the Crown stepped into it. They had a problem on that. So the Crown has to meet both criteria: consultation and something called compelling objectives, quote unquote. It's important, new business of compelling objectives. So basically, the Crown tried to say in the case, well, look, by definition, legislation has a public interest in its compelling objectives, or else the legislators wouldn't pass that legislation. The court said not so fast. In that case, even though it was a compelling objective, the most recent forest licenses were talking about cutting to curtail or mitigate against the pinewood beetle infestation. The court said that's not compelling enough. Yes, there are some public interest aspects to it, but the compelling objective formula that the court said, and this is where they clarified the previous cases, is that there has to be priority attention to how that legislation lines up and aligns and supports Aboriginal interests. Pretty well close to what they said. It's basically, that's the priority. It's not just saying, well, gosh, Enbridge Gateway or some other project is going to bring in billions of dollars of revenue, and it's going to create all kinds of taxes, tax revenue, and for good public purposes. There has to be that public, that Aboriginal element to it as well. And that was both, so the Crown flunked both of those criteria. So so they moved forward on that, and there wasn't even an attempt to draw a compelling objective to the forest license with pinewood beetle. Two more things on Silcoteen. I think, and we're always seeing this, this is my point 11 if you're writing things down, this is the expect Aboriginal groups to seek proof in regulatory processes. Many of you will know that there's various forms of regulatory reviews out there, whether it's the NEB, joint review panels. We hear about these things that make a lot of news. Trans Mountain joint review panel involving the Environmental Assessment Agency and so forth. Aboriginal groups will try to do two things. They'll try to prove out title right in that process. They'll go into there, says the court-like setting, you three judges, panel members, you have the ability to, because we're loading you up with evidence here, you can call a spade, and you can say that that is title. We have title. And the joint review panels have been designed not to do that these days. For one reason alone, from the industry perspective, is that well, that would really cause delay to this could go on forever. And there would be a long delay before that panel can reach a determination as to whether there's title or not. So the ask by the Aboriginal groups on the Enbridge Gateway, some of them have made that earlier ask that that panel review process be used to determine title, probably with some confidence that they could if allowed. Now they're going to court. There's some 18 cases out there right now, all about Enbridge Gateway, challenging Enbridge Gateway, and there's at least, maybe not half, but a good number of them are about this very issue of being able to prove out title, or at least consulting decently about title. So that is, that I think that we'll see more argument about that. That remains to be seen as to whether these tribunals will be the form, or as opposed to a full-blown Supreme Court type of process where you've got all kinds of everything from discoveries of documents, discoveries of people. Stay tuned on that. The litmus test will be the Enbridge Northern Gateway. Last thing, Silcotin and treaties. Very much in play. Aboriginal groups it's not lost on people that Aboriginal groups and their strategists that, well, yeah, we're very much still supportive of treaties, but there are certain aspects of treaties that we're troubled with, and there's room still for some form, aspect, or otherwise of Aboriginal title in a treaty area. Three common examples tossed out by Aboriginal groups. One is, well, the treaty was fraudulent. There's a few cases that are moving their way into a court. One, I forgot the name of it right now, Ontario case about falsified documents by the treaty commissioners. There was a case in the NWT, the Paulette decision, a similar sort of scenario. It was making claims of fraud. They're saying, well, let's just throw the thing out. We have no particular allegiance to the treaty. We think it was just, we were duped. The treaty was a line on a map as far as we're concerned, nothing else. Some First Nations, for example, the Ojibwe in Eastern Ontario, they're saying we were never part of the treaty. Yeah, we look at the line on the map, there's a line out there saying we're part of Treaty 3, I think it is, but we were never part of that treaty-making process. The third example of where Aboriginal groups might go in a treaty context is that the surrendered land, even though the surrender clauses under the treaties talk about quote-unquote land, they did not talk about mineral rights, that is, the subsurface rights, oil and gas included, nor did they talk about water, subsurface and large surface areas. They were talking about land. That was the understanding. There will be litigation. I think right now there's already some case law comment, and there were some of the cases I mentioned earlier talking about mineral rights. And the courts there have said mineral rights are part of Aboriginal title. And so you're gonna face some interesting litigation. I don't know who's gonna bring the litigation, but to clarify what it is that Aboriginal title is that was not conveyed out by the Aboriginal groups when they signed a treaty. I'll leave it at that on Silcotin. I want to just turn very briefly on fracking, then we can have a full-on discussion. I'm way less time on fracking. For those of you who have read the material, you know what fracking is. But I want to tell you where the litigation is. Fracking is really, it's code for a series of activities, different activities that occur. There's some cases in fracking I was involved in one of these, is where the Crown, especially in the treaty area, attempts to dispose of land, give surface and subsurface rights away to an energy company so they can basically do the exploration or the production work. So this is the Bennett case. Bennett and Nexen case were 2 years ago. The argument there by my friends on the Bennett side were to the effect, well, you're giving the Crown, you're basically, you're accepting $1 billion for the land rights from the companies, and this shouldn't be lost on anyone. This is all about fracking. And we should have a threshold discussion about consultation about fracking here. And we want you, the Crown, you should have, but you didn't. This is a consultation case. You should have, but you didn't consult with us about what they call the full build-out scenario. We should have had a fulsome discussion of what we're getting ourselves into here. I was on for Nexen, and we had some very interesting discussions, and we heard a very good argument by my friends from the Aboriginal side. They started talking about this is about death by 1,000 cuts, etc., etc. I probably can't disagree with that too much. But our point was, and the judge agreed with us, that there was there's ample opportunity in further steps, later regulatory steps for the different things that the company has to do to get approvals from the Oil and Gas Commission, for example. There will be consultation around that as well. So that court, the Supreme Court of British Columbia, did not go along with the Aboriginal group arguments that there should be a full, like a 25-year outlook as to what goes on and how that what could happen here, and we should consult about that and so forth. The other aspect of the other batch of cases have to do with water, primarily surface water. If you fly over Northeast BC, you'll know that you can see that a lot of water, but it's all in the wrong places. It's shallow water, it's muskeg, and it's also great habitat. Okay, we're involved in a case now, again, I was on for Nexen. The case is, that decision is still reserved for 13 months and running. We had a lot of really good experts brought on by the First Nation, the Fort Nelson First Nation in that case, including a professor of water, Sean Carey. Does anyone know Sean Carey? He's a big master water guy. And he and 10 other expert witnesses are brought on by the Fort Nelson First Nation did a great job of explaining how there's going to be real water shortages, and Nexen needs that water, and they got a water license to pull a lot of water from shallow water bodies to service the fracking operations nearby. And that gas is going to go to LNG on the West Coast. And there's some interesting intrigue between the Aboriginal groups on the upstream, Fort Nelson First Nation, and their friends on the downstream, LNG facilities. So that's one example. There's a few other water cases underway. We're going to fire up another one probably in April on behalf of another company. There's running through all these is, I've mentioned death by 1,000 cuts. The other term is cumulative effects. Okay, this is, some of you, I think in your study so far might have encountered that term. It is a very complex, it's a difficult concept to really wrap, it's a scoping issue as to how you can scope cumulative effects properly and help that in the decision-making process. I don't think there's a really sound systematic view on cumulative effects yet in any province, any jurisdiction in Canada. I think that's a concept that's got to be fleshed out. My clients might disagree, governments might disagree. That's my personal view. There's a lot of work to be done on cumulative effects. It's an important issue. No one's denying that there's been a lot of oil patch activity driven by fracking recently, even with the low oil price right these days. It's going to continue, and cumulative effects will still be very much part of the policy regime. There's the other issue with contamination of surface water, and groundwater by frac fluids. Fracking is a blunt instrument. You basically grab a lot of water and you drill a hole vertically, then horizontally, 5,000 feet apiece, and then you basically, next step is you bring in these monstrous pressurized trucks, and at 100,000 PSI or something, is just unbelievable numbers, and then they jam the water and the frac fluids into the vertical and horizontal holes, create minor explosions, earthquakes, and then basically release it. And on the molecules of gas come up with water. So your water molecules go left, the water goes right, and you've got a lot of contaminated water on your hand at the surface. And it's got to be dealt with one way or another. You recycle it, or you inject it in deep wells, or you move it to a treatment facility. So it's the contamination issue, and Mrs. Ernst in Alberta is fighting that issue. There's the Ernst case, and she's got a good website if you're interested. We don't have time to go into that case very much right now, but that's her battle, is the Ernst case, is the contamination by a neighboring operation in Canada in that case. What about further litigation on the fracking front? Yes, there will be. There's about 200 U.S. cases on fracking right now, and they are moving towards many of them are moving to final conclusion in the courts, and I suspect, because our legal systems are so similar, there'll be some of those concepts that are going to play into here. But what distinguishes the U.S. and Canada is that there's a lot more leverage in the hands of Aboriginal groups in Canada than there's in the U.S. Beyond the reserves, whether it's Crown land or potentially even Aboriginal title lands. Way more clout legally in the hands of Aboriginal groups in Canada as opposed to in the U.S. I mentioned earlier on that water ownership is going to be a big issue, mineral ownership is going to be a big issue. Certainly those two things are going to play out in the fracking context, whether it's BC, Alberta, and I think equally importantly, New Brunswick. You're hearing a lot of noise of what's going on in New Brunswick. I think what happens in British Columbia often just moves this way like a westerly storm and goes right across the country. And I suspect, I know my friends for the First Nations, they're already doing work preparing their cases, and we'll see them again in court in New Brunswick probably, St. John. It'll be a redo. But that's what's, so all these concepts that are being rehearsed really for the first time in this early stage of fracking litigation in British Columbia and Alberta, we'll see that revised, revisited in coming years.